Hey everybody, today's estate planning question is, can you speak a little on a marital trust? We're afraid our stepmom is not going to follow it. Before we get there, I'd like you to imagine a friend going through a what-if scenario that creeped into their lives, but they were totally prepared because you shared this video. We would appreciate it, as will they. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us. We're going to do our best to get back to you. In due time, of course. It's our hope that together we can help somebody before something creeps up into their life. Now, back to the question. Marital trust. A marital trust really does depend, the structure of it does depend on the document created itself. Because a trust is a contract, it can have numerous different provisions that provide either more or less flexibility. Typically, a marital trust is a bit more flexible in its usage for the surviving spouse than what we call a bypass trust, often referred to as a family trust, which is meant to be a little bit more insulated for the next generation and have some more restrictions so that it is limits the estate tax later. But the marital trust is sort of a flow over trust typically, and hopefully that's what we're referring to here, and you had the right naming of it when you asked this question. But the marital trust is sort of an excess overflow that often has some flexibility there for the surviving spouse to use at the minimum for their needs and sometimes more. But you really have to check the document itself to see what it says relative to the usage of the income as well as the principal. Sometimes those are different in the allowances. There are occasions when income is just a flow through to the beneficiary at the time, and principal can only be for needs, or as we call it sometimes, HEMS, which is the ascertainable standard: health, education, maintenance, and support. For purposes of this video, that's basically your needs at the time that you receive that trust. Maintaining your lifestyle at that stage. Nothing in excess, not luxuries beyond that. So you have to look at the document itself to determine. Now, if your stepmom is also the trustee of that trust, you have to be mindful that there's nobody looking over their shoulder except for maybe you and your siblings to say, hey, you have these certain qualifications. Oftentimes, the trust will say that an independent trustee has the authority to distribute beyond the scope of what maybe your stepmom has the allowance to do. I would ask some questions if you're concerned. Maybe a conversation first with your stepmom, knowing what maybe your dad's intent was, assuming we're talking about your dad being previously married to this individual. And then further, if there is a major concern that these assets were meant to be insulated for you and your siblings, I would ask a litigation attorney to look into it for you. But in most circumstances, if it's there for the spouse and that was the intent of your dad and there's some flexibility, it's there for them for their lifetime. And what will remain will remain. I hope that information is helpful to you or a friend. And please, don't forget to share. As always, take care.